there was the suggestion of a surprise at the submission of a report for Daniel Ofori's, petition, which had been finished. I had to try and find out what the facts were. And that's what I just quoted, where the committee said at the very beginning, when the procedure was being adopted, the committee said, quote, "The trial will be petition by petition. Each of the three will be tried separately," end quote.
No, thank you very much, Samson. In fact, going into this on the first day, I think that the natural assumption of all of us was that the petitions were going to be handled together and that, we'll go sequentially as it was necessary to. Now, in terms of setting the procedures, it became clear that the committee's view was that we're going to bifurcate the process dealing with. And the first time that we met was because there were common procedural issues that would affect all the petitions, then we would take all of them together. In fact, it was during the beginnings, and this later on became a subject of controversy when the former Chief Justice made the press conference as to whether or not her lawyers were given hearing. It was when Mr. Dukusi came before the committee on that day, he said that he was not there representing the Chief Justice, but he was there because he had been informed to come and investigate whether this is truly a committee. That was his position on that day. And so we went in through, and the record will show that, in fact, we went in through whether or not the respondent had been served with the process. In fact, there had been exchanges
on that day you just mentioned.
On that day.
He sat through.
He sat through.
Correct.
In fact, I objected to his presence there because I said that if clearly he's claiming that he's not representing in a legal capacity, then his presence would pierce the in-camera nature of the proceedings. That was my position. Senior Chachikata took a different position on it. The committee deliberated and decided that they would allow him to proceed because we were not going into the substance of the matter and we were only dealing with procedural issues at that point. So all of us were clear when we were leaving there that the petitions were going to be treated separately and individually on their own. There was no conversation as to whether or not a holistic report would be written in respect of all three. And in fact, if a position would have been taken to write a holistic report on all three, it would have been inconsistent with the idea to treat them as separate petitions. Now, again, I would say that it was not clear to any of us.
But in court, cases can be consolidated.
The cases can be consolidated.
And when they are consolidated, they still are tried in their individual cases.
Yes.
And so...
Yeah. No, so yes, I'll come to that. So at no point did we leave, in fact, with any direction, that the report of the committee was going to be one, wholly, or separate. Also, there was no direction and indication from us to understand whether they were going to be transmitted separately or they were going to be transmitted together, even if the decision was taken to write them separately. There was no understanding from any of us that if it was separated, whatever conclusions that were reached, the president was going to act or not act separately, serially, or sequentially. None of those were clarified. And in fact, it goes again into what we say the consistent developing practice around 146 itself, whether or not, and every time we get into this, it's like going into a new process altogether, to be honest. And perhaps I'll come back more substantively to those points. But as far as the first day initial was concerned, it was clear to all of us that this was how it was going to happen. Now, mind you, despite this, even as the first hearings were going on, we had intervened, I think, 3 times. The first way, there's a petition, this that was pending before the committee that we had brought, asking that the committee recommend to the Attorney General for certain persons to be held in contempt. Because we, first of all, took the view that we didn't think that the committee had the power to punish for contempt, that if anything, they can make a recommendation to the Attorney General for that. So we brought that in a complaint therein. And subsequently, we brought the subpoena, listed a number of people and a number of documents that we're going after. Now, there was a lack of clarity as to whether or not each of the subpoena and each of the documents that we required needed to be individual, or that we can put them together as one and request all the documents that we're requiring for. And then again, we met the committee, and the committee's direction was that they wanted each person to be dealt with individually. Now, we understood the committee's reasoning that because, again, of the in-camera nature of the proceedings, each witness should not have a sense or idea of which other witnesses were appearing, and which other documents were being requested in the matter, which we took to be understood to be fair. And I think the last instance that we appeared again was in respect of when the committee had summoned us as to when to begin the process of this. And when we then indicated to the committee that for medical reasons, we're asking for the dates to be changed. Now, the reason why this is important because the second time we appeared before the committee, we had a different understanding that we were going to start almost immediately in 2 days. That did not happen. It took about 3 weeks. And so then, because of I imagine that other issues which had appeared in dealing with the first petition, the timeline that we were supposed to appear in had shifted, which meant that other accommodations needed to be arrived at. And so it was clear to us when we were informed, in fact, we had a conversation with the third petitioner, and we had written to the registrar that if the third petitioner was ready to go, they could take the third petitioner even before us. The third petitioner reached out and said that his understanding was that the committee wanted to continue sequentially, so they would still take the second before they take the third. So those were the conversations. Again, the report was made to the president.
So this question substantively to you and to Inusa, will it not be tidier that even when you consolidate cases, 2, 3 cases together, the law is that even though consolidated, they'll be tried separately.
Yeah.
But once they are done, because the facts in one case affects the other, it is the reason you consolidate them. Once you are done, the judges will normally perhaps give one lead judgment. Then the others, they may give a small, brief judgment and refer to other matters. Will it not have been tidier to wait to finish all of the petitions and then render the decisions, even though separately?
You know what, to be fair, the first point I'll start with is, I, for instance, had a problem with bifurcation. I'll come to reason.
Is this a bifurcation or a trifurcation?
A trifurcation of the petition in many respects. Because one, there were certain documents and things that had been solicited and obtained in the first petition, which were relevant to the second petition. Now, we internally had to debate whether or not, because they're not part of the record, essentially, as regards to us, do we have to then subpoena those matters as well? What does that augur for the length of the process and the speedy nature of which we have to deal with this? So in my opinion, because of, again, the law, because we have taken a technical nature to how we are dealing with this, more than we should, in my opinion, that it creates then those evidentiary questions as to what is part of the evidence and what is not part and not to be excluded. But I do sincerely believe that, in fact, when I saw that the committee had reported to the president, my feeling at the time was that perhaps I don't know what the substance was, the president was going to wait and hear the petition that he himself had referred for a committee to listen to before a decision would be taken in respect of it, irrespective of what the decision was. So that was my feeling. So again, it is surprising to me that a decision has been made in connection with the Chief Justice, because now we're asking ourselves, we cannot move against a suspended Chief Justice. I mean, in fact, the nature of the person before the respondent has changed. And our petition was against a sitting Chief Justice. So we don't even know whether technically in law, these petitions, the second and the third, are still viable. There's also the Supreme Court decision in Ansuji Abuo, where the Supreme Court says that if the person is retired, you can't bring proceedings against them. So the person is no longer there. So I don't even think that this can continue as they are. So my feeling was that if in any, whatever the decision that the committee took to report on the first, and in fact they did inform the president that they were going to hear the second, that I think that the presidency should have waited and gotten the full benefit of everything before the procedures. And whatever the case may be, it hasn't happened now. Hopefully in a way in which, in 1992, when we decided to separate the presidential elections and the parliamentary elections, and the MPP then boycotted the second, we then later on decided that we're going to hold both on the same day, that it might inform subsequent proceedings, that this is how we're going to move on them. But in my opinion, I think that perhaps a more tidier thing would have been, one, to report on them holistically, or two, that the president, having received the one, should have waited for the others.
Okay.